It's 2:45, right? So we're going to begin. Thank you all for attending this later in the afternoon seminar that our firm is giving, Kagan Lubick. My name is Jack Lepper. I'm pleased to be here with my partners Adam Finkelstein and Denise Campbell and David Schaefer. If you like the substance of what you hear, thank Denise and David. They put in a lot of the legwork on this, although Adam and I were doing some of the talking. So we're going to start off. Well, let me start off by doing this, just so I have a little bit of help. How many folks in the audience live in condominiums? Raise your hand. All right, hands down. How many are in co-ops? Okay. Without having done counting, about at least 3/4 of you are in co-ops, not condominiums. Generally speaking, it's easier to accomplish rules and regulations in a co-op because you're a landlord and the shareholders are proprietary lessees, and that gives you a little bit more power. But we're going to talk about all these issues in the context of both co-ops and condos. How many people attended our seminar last year, just out of curiosity? Okay, so thank you for coming back. Now, opening up with Local Law 147. Okay, the issue of smoke within your apartment building. And as of August 28, 2018, each of your co-op and condos must have a policy in place addressing smoking in your building, whether it's permissible in common areas, including the outside common areas, or not. And that policy has got to be provided to all of the residents, all unit owners, proprietary lessees, condominium unit owners, and any tenants of those people as well. So you have to have that in place. Just by, again, way of hand showing, how many folks in their co-ops and condos already have these policies in place? And how many do not? All right, guys, so you have a little time, but you must get it done. And it may be helpful to you that some of the materials we provide for you will give you a big head start. Okay? So there are a couple different issues here. If you're a co-op, it's a city ordinance rule. Okay, it's not the fire department. So if you're a co-op, okay, you have to decide whether you're going to allow smoking within apartments or prohibit it altogether. Now, your house rules likely already provide that no shareholder or lessee or occupant can cause a nuisance, and secondhand smoke might be deemed a nuisance. Okay? That is different than having a blanket, you may not smoke within your apartment in the building. And while some will suggest that amending your house rules to accomplish this will be sufficient, our strong recommendation is that you amend your proprietary lease and your house rules. And you will see in the materials we provided for you a language that will address amending your proprietary lease and your house rules. Now, if you live in a condominium, and you want to prohibit folks from smoking within the building and smoking within their condominium units, you must amend your bylaws. It's a different process. Okay. You should have been handed packets as you walk.
They're going to be getting them when they walk out.
Oh, you're getting them when you walk out. Okay, that way you have to focus on us while we're talking. I see. Very, very good. Okay, so you must amend your bylaws, and amending the bylaws in a condominium is going to require a unit owner vote. The percentage will be determined based on your particular bylaws. Often it can be 2/3 of owners with 2/3 of the common interests, but the proposed language is covered in the materials you'll receive as you leave.
And it's on the screen there as well.
Oh, you're also seeing some, but I don't think you're all going to be doing the Evelyn Wood speed reading.
Right.
So that it'll be easier to walk out with it. Don't take notes. We already took your notes for you. You'll walk out with it. Okay? The law governs both the conduct of board, management, and residents. You kind of can't mess this up. You got to do it right, and you have time. Now, what's interesting, because we just did this on one of our buildings on the Upper West Side. Okay, they kind of took a poll, a straw poll of their residents to get a feel, a pulse of the people. What do people want? Do people want there to be a smoking ban throughout the building or not? And the problem with smoking, and this is not in the materials, guys, the problem with smoke in a building is it's all but impossible to stop it. All right, and I'm not an engineer and I don't play one on television, But there are all kinds of conditions within buildings that allow smoke to travel from place to place. One that most people don't understand is negative pressure. That buildings have certain pressure within them to push air out of the building. But as doors and windows open, air gets sucked into apartments and moves around. Also, particularly in older buildings, there are just openings in every which way. So no matter how hard you try to caulk, plug, put in filtration systems, smoke will often travel from place to place. And you have to determine within your building how you want to address this. Okay, and it's really a building by building thing. I will tell you that when we speak to real estate brokers on all ends, most do not advise that smoke-free buildings have an adverse impact on building value. All right, because often people who smoke or people in the building will say, how will this impact the value of my home? Are you going to reduce the pool of people who may want to buy in? And what we're hearing from brokers is that's not likely the case. And in fact, many buildings are moving in this direction, and if you don't, you may become the building that allows smoke. Secondly, you probably are familiar with court cases that come up from time to time where people complain. And those cases are very, very difficult. There's issues of proof. The damages could be severe if there's actual smoke infiltration that causes harm to somebody. And so these are all issues that you have to address. I am not going to read the law to you. Okay, it's already covered in the materials that you're going to walk out with. So there's no need to do story time. And likewise, I won't do the rule and regulation. Questions that commonly come up are, what kind of smoke are we talking about? Okay? We were going to do a little thing with a pipe and a cigarette. We didn't do that. Okay? The answer is pretty much all smoke. All smoke. All right? So whether it's a cigarette, whether it's an e-cigarette, whether it's anything else, okay, that might be an issue. Then, of course, and I'll keep you from having to ask the question, what if folks are smoking something else in their apartment? How does that impact things? And what if it's for medicinal purposes? Okay, so I'll just hit it so you don't have to ask it, although you can ask it after we finish. One, if it's for medicinal purposes, it follows almost like under the disability law. You enter into the interactive process in determining whether someone is really using this for medicinal purposes or it's an excuse.
But one point, currently in New York State, medicinal marijuana use is not through smoking, it's only through edibles. So if someone is claiming that they need it for medicinal purposes, the edible version is what most people would be utilizing if they're doing it legally. That may change. I mean, obviously there's a lot of discussion all over the country about recreational legalizing for medical purposes, different types of standards for what type of illnesses. So just bear in mind, because I've encountered it, people said they need it for medicinal purposes, but they can't demonstrate that they are satisfying New York State law with. So
that's not going to fly. Okay, it's not going to fly. Regarding people in co-ops, amending your house rules can typically be done by a board vote. So at any duly called or held board meeting, you can pass that rule. However, amending your proprietary lease is going to require a shareholder vote at a duly called meeting. Now, you can do this with what are called directed proxies. That's a form of proxy which says, I want to have our lease amended to ban smoking or have this new rule apply, okay, whatever that rule may be. But that's how you have to do it. And different proprietary leases have different thresholds. Typically, it shows having either 2/3 or 3/4 of all the outstanding and issued shares. So that's how you would go about it. Again, in condominiums, the board could typically amend the rules and regulations. All right, in co-ops you have house rules, and condominiums rules and regulations, but it will likely require a vote of your unit owners to accomplish an amendment to the bylaws. Again, that can be handled through a directed proxy. Your firm, your management company, or more likely the law firm that you work with will be able to walk you through that process. It's not terribly complicated, okay, but you have to do it correctly. You want this to have teeth, okay? And
that again is if you're talking about an outright ban. If you're talking about limiting how people smoke, for example, making policies about caulking, door sweeps, air purification, things that allow smoking but are rules to try and prevent the migration, or rules that prohibit it in certain common areas, on balconies, on courtyards. That's something that you don't necessarily need to amend your governing documents. The boards can typically do that under governing documents through a rule amendment.
Because you're all already board members, you know that nothing happens overnight. So you have until August 28th, 2018 to get this in place. So my suggestion is, it's almost May Day. So you need to address this immediately. And again, you have a big head start, and your firms that you work with will likely have also sample rules that you can look at as well and get it done. So that's we're going to take questions. We're going to take questions on all. If you're going to prohibit smoking within an apartment, then we believe it must be in the lease. Okay? If you're going to prohibit it in the common areas of the building, I think your rules and regulations will cover you. Okay? Yes. Yes, you'll have them. All right, so we're going to take most of the questions at the end. We're last, so we have a little extra time. Okay, we want to try to get through the material. And the next subject we're going to talk about is the change in the law regarding conflicts.
Conflicts of interest. This, fortunately, in my experience, is not something that comes up that often. I really can probably count on one hand any instance where I've had a board actually engage in entering into a contract with someone who's a related party. And when I say that it hasn't been disclosed. We've had some situations, but it's been disclosed, which is really what the law has always required. Those of you who've heard about this new change, there are really two components to the law with regard to what boards are supposed to do with conflicts. One of them has been on the books for a long time, and in fact, it's part of your fiduciary duty, and I'm sure you've all heard of a fiduciary duty. But basically, any contract you enter into with a related party has to be disclosed. Otherwise, that contract is voidable. And that's under BCL 713. And that, like I said, has been on the books for some time now. And the focus again is that board members are supposed to act in good faith with a degree of care of an ordinary prudent person. And that includes not acting in bad faith for one's personal gain. So if you are a board member and you are, as a board member, your board is now entertaining doing business with a vendor who you have a financial interest in.
You or anyone related to you.
Exactly. You must disclose that to your fellow board members and recuse yourself from voting on that particular contract. You can participate in the discussion, but really when it comes to voting, you should be stepping out of the room, letting the disinterested board members speak to the issue of whether they want to pursue that particular contract with that particular company, and that will purify the contract and not make it voidable. It will be a legitimate binding contract without the concerns of being set aside by Section 713. And in the materials you'll see there are parameters, how you go about it, which I just kind of summarized. When we get to 727, that's the new legislation. And for condominium owners, when this legislation was first passed, it referenced under the Business Corporations Law and for the Not-for-Profit Corporations Law that it included condominiums, which had people like us wondering, well, how does that work? Because condominiums are not formed under Business Corporations Law or Not-for-Profit Corporations Law. They're formed under real property law. Well, as of April 18th, I'm getting ahead of spring right into summer, that law was amended. It was done in a way that was a little bit of a hodgepodge, but now the BCL will reference condominiums formed under real property law are now covered. So you kind of have this hybrid situation, which may be subject to some further change, but the one thing we take away from it is that the legislature in the state was very clear that they intended condominiums to be subject to the same law. So if you're in a condominium, you know, this Band-Aid approach the legislature implemented recently will cover you, and if you are a typical co-op formed under BCL, which most private co-ops are, you are always subject to this new requirement to disclose any contracts on an annual basis that you've engaged, that the corporation has engaged in with related parties or parties that you have an interest in. This annual report, and again, it'll be in the materials, you have to list all the contracts voted on by the board where one or more directors was interested. Name the contract recipient, state the contract amount, the purpose of entering the contract, the record of each meeting where such contract was considered, including the directors in attendance, voting records of all contracts, and how each director voted on the contract, date of each vote, and the effective date of the contract. So you can see from what the legislature is looking at, they really want to make sure that there's this piece of a document floating around for all of the people living in your building whose money you're spending. They want it to be very detailed and documented. Most of the time your minutes will cover these things, but your minutes will you'll have to be sure that your minutes reflect it. And this is required to be disclosed each year. And every board member has to sign this statement, either a statement that there were no contracts that fall into this category, or then list in detail the ones that do and provide all of the information related to it. Now, the one interesting thing is there is no specific penalty under the statute. However, if you are violating a law, it raises certain questions as to whether your D&O insurance would necessarily provide you with indemnity if you are then sued by one of your shareholders because of a contract with a related party. Nobody wants to be in a situation where they get that letter from the carrier saying, yeah, we understand you made this claim, it would ordinarily be covered, but since it's a violation of law, we're not going to indemnify. They'll probably defend you because the duty to defend under D&O policies is broad, but the indemnifying you for any damages sustained, you don't want to be on the wrong side of it.
They may also claw that money back if you're found to have done the wrong thing.
All right.
At the end of the day.
Understand this law is new, so there's not really a record that we can point to, and there are some questions out there that we as practitioners, and I'm sure you as board members now being aware of this, may have. I don't know that we're going to necessarily be able to answer all of those questions, but some of the things that have come up is what happens if you are a board member but you're also a real estate broker, and you are have applications that you are involved with on your business side, your job side, that now come before your board. Most buildings that I work with, that we all work with, those board members typically do recuse themselves. And most board members know because it will say on the contract who the broker of record is. But that's going to be something that I will certainly be recommending to boards, that if you are a board member and you are engaged in the business of brokering apartments in the building, that be included in the statement. Most people know it anyway, but I wouldn't want to have a situation where there's a case that comes up that says that that's something that should have been disclosed and it wasn't. I'm going to err on the side of caution. The other situation this may come up in is with management companies. And while they're not board members, they do serve in a fiduciary capacity. And many management companies provide a much more robust amount of services than just pure managing your building. And they sometimes have related companies that are happy to bid on jobs, and in some cases they're going to be the best opportunity for you to get the job done for a good price. I would certainly recommend that if your board is engaging in contracts with a management company or a company related to your management company, that you simply disclose it. It's going to be known. Usually the names are similar. You don't have totally different names. So I would err on the side of including that in your disclosure on an annual basis. And boards have said, well, when do we have to do this? I think you should really treat it like with your smoke detectors. When you roll the clocks, you're supposed to change a battery. I think when you send out your financial statements or when you're having your annual meeting, you include it with your notice. Don't make a separate mailing of it, and just have your management company know that each year when we do this, again, financial statement or meeting notice if they're two separate times, and send it out with that. And That's what I was just going to get for you. Its effective date, it's by once per year, and it went into effect as of January 1st. So you have until the end of the year to do it. So, if you haven't had your annual meeting yet, you may want to consider doing it now, getting it out of the way, and then doing it on an annual basis at that point. Or, if you're not prepared to do that, do it before December 31.
All right, it's prospective, yeah.
Going forward, you don't have to look back.
Just a few comments on what Adam was discussing. It's often asked, does a board member have to recuse themselves if they have some kind of an interest? Okay? And the answer legally is not necessarily, no. A board member is a board member. Now, the board member may choose to recuse himself. It might make it a much more fair process. It might also not chill other board members from speaking freely. So we might suggest it's a very good policy that a board member who may have a conflict or has a conflict, even if they disclose it, that they recuse themselves from certain discussion, so there can be a free-flowing discussion about what the contract and what the related issues are. Secondly, if anyone happens to be in a Mitchell-Lama Co-op here or any other co-op that was formulated under the not-for-profit corporation law, a law applies there in the same manner. While there may be no penalty for damages, Adam mentioned insurance. If it turns out that the contract that was entered into was not, in fact, the better offer to the corporation, that is to say, there was a lower bid from an equally qualified company, there's the issue of damages, whether, in fact, the corporation was harmed by the entering into of a contract for consideration that was greater than not necessary. And that's a legitimate claim. Okay, so just be aware of it. The whole broker issue, whether someone who's a real estate broker has to disclose, that's a question in flux. That may be determined by the courts. I don't want everyone to walk out here and saying, Jack and Adam said, or Adam and Jack said, because the law as written requires you actually enter into a contract with the corporation. The broker is not entering into a contract with the corporation, though they are the beneficiary of a contract that the corporation has to consent to. So I think that you'll talk to different lawyers. You'll talk to two lawyers and get four opinions. Okay? Just be aware of that. That's not black and white.
It's again erring on the side of caution because we don't know how these laws are going to be addressed by the courts, and that's just my personal recommendation.
And the issue of, we're going to get to questions, and the issue of what other services might be provided through management, be aware often it's insurance. Okay, it could be brokerage for an underlying mortgage. It could be project managers for construction-related things. Those are the types of things that Adam was referring to. Anything else on that one? No, enough. We'll take questions at the end. All right. The next one we're going to talk about are balcony enclosures, which we didn't frankly think we were going to talk about, but things are changing. This is like legitimate breaking news. Okay. One, just out of curiosity, how many folks in the audience have co-ops where there are enclosures, which means there was like a roof setback, and now it's enclosed and incorporated into an apartment? Okay. So there's not a lot of you, but this is an important subject for those who are impacted by it. Way back when in '76, there was a law that basically said if you have these enclosures, you have to deal with it, but it was a very loose law, and it suggested that if the enclosure was not affixed and there was not electricity, you didn't necessarily have to file, and it wouldn't necessarily affect zoning issues. That was the concept. Okay, and then in 2014, the Department of Building suggested, well, no. In connection with your then Local Law 11, now FISP, right, Facade Inspection Safety Program, we're going to require that your engineering firm, architectural firm, when they file their report, advise whether any of these enclosures exist and whether they were properly filed with the Department of Buildings. And that rate, and if not, the report had to provide that these were either dangerous conditions or safe with a repair and maintenance program. So that became the issue. This put a chill through the industry because, frankly, the concern was not that you couldn't legalize, okay, or file for these things with the Department of Buildings. The question was whether, as a matter of zoning, the building was overbuilt with permissible square footage. And so folks like us started serving letters on everybody that had these enclosures saying you might not be able to keep it because the building might not have the permissible square footage to allow you to have it. And that created all kinds of upset. There was a further filing bulletin by the Department of Buildings in 2017, which also discussed the impact of these enclosures, and the city and the Department of Buildings started to realize what they had unleashed. They never really took into consideration that many of these enclosures on these roof setbacks were incorporated into apartments many, many years ago, and now these buildings were technically overbuilt with regard to zoning and permissible square footage, and there was just a lot of upset. It was really not what they put the law in effect to accomplish. The intention of the law was to make sure that these setback enclosures were done safely, that they weren't simply sitting on the parapet walls, that they weren't going to blow off in a hurricane and frankly kill somebody. So as of now, the DOB is somewhat in flux as to how they're going to handle this whole issue of the zoning and whether they're going to require people to remeasure their buildings, see how much square footage they're allowed to build, and whether these enclosures are going to take them over permissible zoning amounts. So this is brand spanking new. And what I'm going to suggest to any building that's impacted by this, speak to your architect, engineer, attorney, and managing agent. And frankly, they're going to likely tell you, we don't know, but we know it's an issue. Okay? And what we're going to advise our folks is sit tight. All right. That said, if there's an enclosure that's not safely installed or that's leaking and allow water to penetrate into the building, that's a whole different issue. That you got to deal with no matter what. Okay? But if the issue or concern is that our building will now be overbuilt and we have a zoning issue, all right, that issue is on hold and is being discussed, and we're all waiting for an official bulletin from the Department of Buildings. It's only affecting a few people in the audience, so I'm not going to spend more time on it, but just be aware of it, because it's I'll tell you candidly, one of our clients, one of the shareholders, is in the process of taking down their enclosure on the zoning issue, and we feel terrible because now the law has changed. All right, so we notify them and they can reverse it, but that's where you should be aware of it. Okay, next topic. I'm sorry? I can't hear you, but I'm going to hold you off until...
What about the aesthetics?
Well, they have to restore the building to its condition prior to its being installed. Okay, but we'll talk about that a little bit later in the question and answer time. Yes, Adam.
Okay. Employment law. As co-ops and condos, you typically, I assume, have staff. Some changes in the law are things that you should have on your radar when you are hiring. There are certain things that were done for years as part of due diligence when you're meeting with candidates that have now been deemed illegal. Criminal background checks. Basically, it is now impermissible for you to do a criminal background check before you offer employment to a candidate. It used to be you get a candidate, you do all sorts of checks, including was this person in jail, and if they were in jail and got out and are now looking for a job, you could use that as a basis to not hire them. That is not permitted. What has to happen now is you interview people. If you want to extend an offer, you can extend a conditional offer of employment. I'm sorry. You can extend a conditional offer of employment, and then you can do your criminal background check. If the criminal background check comes back with some history, there is a form, and I don't know that it's on the in the materials, but it's under the Fair Chance Act notice, and if you go to the New York City Commission on Human Rights, there's this form that has to be filled out, and you have to submit it to the candidate for employment. And basically, you're going to have to justify a withdrawal of employment based upon a reason that the past criminal act makes them unsuited for the job. So, for example, if you are hiring a superintendent and the superintendent had a burglary in the past, and there's a concern now because the superintendent maintains keys to your apartment, that would potentially be a legitimate reason that you would withdraw the employment. But if it was not a burglary, if it was some other type of criminal act that wasn't really related to something involving their job duties or their involvement in your building, that would not be a permissible reason to withdraw the offer of employment. So, again, ways that we've kind of looked at things in the past are now going to have to change. Same thing for credit information. Many times on an application for employment, there's an authorization to perform a credit check. That type of an inquiry is impermissible. You cannot use someone's credit history as a reason to not hire them. It would be discriminatory and actionable. Salary history. Basically, the law, as of October 31st, 2017, made it illegal to ask a candidate for employment what they make. You can ask what you would like to make, what are your salary demands on a going forward basis, but you cannot ask them what they make. Again, you must pay on the skill and qualification, not on prior salary. This one's a difficult one because if you inadvertently get information on what their past salary was through whatever type of due diligence you're doing online, let's say, you cannot use that in your deliberation as to whether you're going to offer the person a job and at a salary somehow related to what their past history is. And the penalties for this are fairly significant. They're very significant. $125,000 for an unintentional violation and $250,000 for intentional. The premise behind the change in the law is that people should be paid based on their merit and not based on circumstances that have brought them before you to date. So again, you can certainly ask, what are you looking for in salary? And that's okay. What type of benefits do you need? That's okay. But you can't say, what were you making at your last job? That would be an impermissible inquiry into their employment, their salary history. I think that covers this. This was a short topic. I got bed bugs.
Okay. I'm going to talk about bed bugs.
Yeah, this is one that, look, thankfully for some reason bed bugs were a pretty prevalent problem several years ago, and thankfully I haven't had too many instances now, but it was bad. So whatever the exterminators are doing, I guess they're doing right.
Roscoe.
But every time I had a building that would talk about bed bugs, I would start to itch. So I apologize to you in the audience if you're going to start to itch. But this is something that's been on the books for a little while, but we bring it to your attention. But there is now a bed bug disclosure requirement. Basically, you are required to post, to distribute and/or post a notice indicating the bed bug activity that has taken place in your building in the past year. So it's when you have a tenant. So in a co-op, it's a real issue. In a condominium, it's not so much an issue because it's not a landlord-tenant issue, although if you are an owner of a unit in a condominium and you rent your apartment out, you would be required to provide this disclosure notice. Yeah. Well, you would certainly, I don't know of anyone that would have a problem saying that there were none, but there is a city form that you can get on the city website under New York City Housing Maintenance Code, and you list the tenant, the subject premises, the apartment, and then there are boxes you can check. One is, the good one, there is no history of any bed bug infestation within the past year in the building or in any apartment. So we want to check that one. Sure, there's a form. The question? I'm sorry. The question was, do you have to disclose if there was no activity? And the answer is yes, and you certainly would want to. And the form that the city recommends using has the first box to check is no history. The next box is, during the past year, the building had a bed bug infestation history and has been subject of eradication measures. The location of the infestation was on blank floor. Next box is, during the past year, the building had a bedbug infestation history on the blank floor and has not been the subject of eradication measures. That would be a bad one, because you got a rampant situation and, these things blow up. The next box is, during the past year, the apartment had a bedbug infestation history and eradication measures were employed. During the past year, the apartment had a bedbug infestation history and eradication measures were not employed. Now that's getting into the specific apartment that you are dealing with. And then there's another, which I don't know what others there were. Maybe you would say that there was a problem, it was eradicated, it wasn't solved, we eradicated it again, and we're trying to get those suckers. And then you would sign it and provide.
That's a legal term of art, everybody.
and provide it to the tenant and the people in the building. And in my experience in the co-ops and condos we represent, this typically becomes a conversation at the board level, and it would typically find its way into the minutes. So someone, if there's a concern that it may impact sales in the building, I think you're probably going to have that problem anyway if you have it in your minutes, because anyone buying an apartment would typically review your board minutes, and if they see discussion in the minutes about that, or they look at your financial statement and they see an extermination fee that jumps up, that I certainly would start asking questions. Well, the question was, are buyers allowed to see minutes even though they're not shareholders? Well, the answer is technically no.
I don't know that we would represent a purchaser of a co-op if we were not permitted, in part of our due diligence, to review the minutes from the building our client was looking to buy into,
right,
whether it be a condominium or a co-op.
So
I'd be very concerned if, look, one of the first things we ask, if we're representing a buyer of a co-op or a condo, is we want to know the history relating to that apartment and to the building. All right. Otherwise, someone could buy in and they don't know what they're buying into. And if a board is going to say we can't allow you to see what's going on within our building, then we're going to write a letter to our client saying we think you probably should look elsewhere to cover ourselves.
You're buying a mystery that could wind up costing you money and a lot of headaches. So, for those who didn't hear the question again, it was, do you have to provide your minutes for review to a purchaser? The answer is no, but if you don't do it, you may find sales falling off a cliff. As far as an attorney, the question is, would it be an attorney reviewing the minutes versus the purchaser themselves? It's the same thing.
It's a policy
It's the same
issue.
thing. I mean, most of the time, I guess because it's counterintuitive, we represent the people buying. We do the due diligence. I guess we have had some instances where our client felt comfortable enough to do the review on their own. If they were prohibited from seeing it, we would obviously say we want to see it, and we would go see it. And if we were prohibited, we would then be very concerned. Now, in some small buildings that operate a little less formally, maybe they don't have minutes that they're supposed to maintain, we try and work around it. And one of the things that we typically provide in the form of a questionnaire is a list of questions, and bed bug would be one of the. Leaks and bed bugs are definitely things that we ask for as they impact the building and or the apartment that we're targeting for acquisition.
I mean, look, guys, we're New Yorkers, and New Yorkers like information, okay? And we're all pretty sharp, all right? So my suggestion is that if you try to withhold information from your current shareholders or owners or future shareholders or unit owners, things will not likely go well, okay? People are understanding if they think you're up, if you're up front and straight with them. And if not, they figure it out anyway, and that is don't trust you. So that's our general advice.
And now we have this law that actually requires a formal disclosure, as I just highlighted.
Right, we're going to take the questions, and we're going to work our way across and back. So we're going to start here, and we'll get to you. Yes?
Okay, so the board members have to disclose. How about management that has amazing relationships with some mortgage bankers, some plumbers, some maintenance people? Do they need to disclose?
No. I mean, also remember, as I said, this is a law that is on board members and their contracts with the corporation. I expanded it to say that, it may be prudent to disclose when management companies are providing services. But what you're explaining is the ordinary course. I mean, many times that's one of the big selling points of a management company, besides their actual service to your building, is the relationships they have and the savings that they can achieve based on their relationships and the number of buildings they
Well,
bring. So the answer is you would not disclose that. However, if the management company owned the company, or they're an officer on your board, or somehow a director, which would be unusual, but that's where I suggested that it's better safe than sorry and disclose that. But the ordinary course is for management companies to bring you vendors that are unrelated, and that would not be something that you would disclose.
And by the way, if you have sponsor-controlled boards, or your co-op or condo is still managed by the sponsor, this very much hits home. Yes. One second. The question was the impact on management with regard to the disclosure law. Do the management companies that may have good relations with certain vendors have to disclose those relations? The answer is no, but it's a good question for you as board members to ask. You know, we're often asked, what's your relationship with the managing agents? Are you working for us, or are you working for them? Okay, and that's the question. And look, it's hard for us. We represent a very large number of co-op and condos, so we have relations with pretty much everyone in the industry. Okay, but at the end of the day, it's got to be made very, very clear to you that the people working for you are working for you. Okay, in the long term, that'll work out better for them too. But that was the question. Yes, sir.
If you have a sponsor who's the managing agent and is a real estate broker, sells his own apartment, which is a sponsor apartment, so it's under special rules, it doesn't have to come before the board, does that need to be disclosed as well?
Are they a board member?
They're a board member.
It's sure. The question is if you have a sponsor wearing multiple hats as an owner of an apartment, as a manager, and still the sponsor of the building, or they're still involved as a sponsor because they still own apartments in the building, how does that impact the disclosure law? The law does not differentiate but what type of director you are, whether you're a resident director or a sponsor. So they would be required to disclose any dealings they have related parties. So even to the extent of the management agreement with their management company, that's something that board member, sponsor board member, would be required to disclose.
But that sale of that purchase doesn't come before the board.
Well,
it's not something that we...
Right, and again, that was my suggestion to err on the side of caution when you have a board member broker. But that is not something, I mean, if you read the language of the statute, it doesn't refer to that. It's contracts with the corporation, and that would not be a contract the corporation is involved with.
Yes, sir.
You mentioned before there are restrictions to nonprofit co-ops and condos, but Mitchell-Lama Article 2 is limited profit, so are they covered too?
Well, you have to look at your Mitchell-Lama Cooperative Certificate of Incorporation and bylaws, because some Mitchell-Lamas were formulated under the not-for-profit corporation law, and some were actually formulated under the business corporation law. So you'd have to look at your certificate of incorporation. I'm familiar with the issue, and they're all different. I know, I appreciate it's limited, I understand what you're saying, but it was organized in one of two ways. It was organized either under the not-for-profit corporation law or the business corporation law. All right, we're working this way to this other room. Yes?
Question, when you're hiring independent contractors, are you allowed to ask them their conviction record and salary history?
The question is, when you're hiring an independent contractor, do you have to ask, can you ask their criminal background and employment history, salary history? They're an independent contractor?
Yeah.
Probably you could, but what concerns me there is many times independent contractors, the way you handle them and the relationship you have with them, they become your employee. If you exert too much control and too much direction over them,
But if you're hiring a company to do your local law 11 work or landscaper.
Oh, okay.
You don't want to, for example, if they have a very big,
I think you can.
I think you can. Yeah. That wouldn't fall under the statute.
Yes,
They're
ma'am.
not your employee.
Okay. The question was, is there potential liability if folks are reviewing minutes? Okay, it's not necessarily related to these issues, but reviewing minutes, and then they disclose what's in those minutes to the outside world. All right, so here's my general comment to that. Maybe. It depends what's disclosed. One of the things that we strongly suggest to all boards is that you're careful about what you write in your minutes. Raise the issues, but don't put anything down that because it's all discoverable. Even if it's not by invite, it's all discoverable. And if you put the wrong things down in your minutes, it can come back to bite you. So I'm going to suggest to you that I don't know because some boards like to write a narrative of every single thing said. That is a recipe for disaster. So, in our view. So the answer is it depends, and we would like to think that boards should write minutes in a way that they can be freely reviewed by everybody without causing harm to the corporation, and only provide such information that should be revealed if someone was going to review the minutes. So the answer is it depends. If those minutes said yes, that Jack Lepper is behind in his maintenance because he lost his job and all these other things, or he's in the middle of some kind of other controversy, yeah, I might come after somebody saying, why'd you publish that? No one's business. So the answer is it depends. I want to get to it first. I want to try to stick on the topics that we're discussing today. Yes, ma'am.
We're trying to take our building non-smoking.
Yeah.
And we're not daunted by the 2/3 majority.
You're a condominium?
A co-op.
Okay.
But we have recently refinanced, and we understand that as part of the mortgage that we would have to refinance again if we go non-smoking.
Who told you that?
Yeah.
My board president.
That would be unusual.
Who's your lender?
Yeah.
I don't remember the name.
Okay,
Yeah.
that catches us off guard. Look, I don't know what your loan documents say, but that would catch me off guard. I'd be surprised by that.
I would be very surprised at
Now, your loan documents may say that if you want to amend your proprietary release, it requires the lender's consent.
Right.
I will suggest to you that I don't think lenders are going to find that to be an objectionable change in your proprietary release.
that. Right.
Yes.
Right.
To prohibit people who prohibit indemnification of people who, shall we say, take money from the co-op, who steal.
A law prohibiting indemnification of board members that steal money from.
Yeah.
Yeah. That. Well, I don't. I'm not.
The question in general is, if a board member acts in a wrongful manner, is the indemnity provision that's commonly in your corporate documents enforceable? And that's the bigger question. And the answer is no. If you act outside of your authority, all right, if you act outside of your authority, and stealing would be outside of your authority, okay, not only will that indemnity not likely apply, but your directors and officers insurance policy, while it may protect you to see whether you did the wrong thing, once it's determined that you did the wrong thing, will not indemnify you and will claw back and ask you back for all the legal fees.
There's a long list of cases where board members have been found personally liable, discrimination cases. I mean, there have been situations where board members are found guilty of illegally discriminating based on race or religion, and they are personally liable. The people who engage in it are personally liable, and the indemnification language never applies to that. It's against public policy.
That's financial fraud.
What's that?
I'm talking about financial fraud, not.
Same thing. It's
Same
an
concept.
illegal act. Violating the human rights laws is a violation of law. Stealing money is a violation of law. I don't know of any legislation that is further emphasizing the impropriety of that. I've never heard of an indemnity covering a criminal act.
And can a board vote to cover the liability of that person who has committed that criminal act?
That would be,
I think
again,
the entire board would put themselves at risk in doing
Yeah.
so. Yes, in the back.
Remember what I said about fiduciary duty, duty of care, and good faith? I don't know how you could justify that as being a legitimate corporate act.
Yes, in the back.
I'd like to know if, as a shareholder, if as a shareholder, is the list of other shareholders, we can see who they are
Yes.
and
Yes.
get the addresses and information
Yes.
like that?
Yes, there is a statute under the BCL that allows a shareholder to request You may be asked to provide an affidavit saying that it's for a legitimate corporate purpose, meaning if you were looking to get the list because you wanted to sell insurance to them, that would probably be improper use and you wouldn't be allowed. But if you wanted to have it for communicating with your fellow shareholders, it's under the business corporations law.
Addresses, emails?
Emails?
Well,
Emails?
the way that that statute's been interpreted, it's you are entitled to communicate with your fellow shareholders in the same manner as the board communicates. So if the board uses emails, then you are entitled to emails. If they use mailing addresses, they're entitled to mailing addresses.
Yep.
Phone, I don't think would be appropriate.
Yes, ma'am.
Thank you.
1 second, he's coming to you with the mic.
Yeah, right to your.
Where have you been all my life?
Regarding the conflict of interest with the related company to management, the insurance, are you required to report it when you select the company, or do you have to report it every year when you renew?
No, it's an annual requirement to disclose it to your shareholders. Whatever contracts you entered into for the prior year. So you accumulate whatever contracts. You only are required to disclose those that have a conflict. So if you did it today, and your policy is going to be that you do it at your annual meeting, when your annual meeting notice goes out, and let's say the annual meeting notice is in January, you'll disclose the contract that you entered into in April.
Any more questions? Yes, ma'am.
What is the requirement, legal requirement, sharing those?
Technically, shareholders are not entitled to, as a matter of law,
Unless-
the board minutes. They're entitled to the annual shareholder minutes, financial statements, and the list of shareholders.
Unless your corporate documents read differently, which is possible, or unless there's a litigation and there's disclosure. Okay, you'll get them if you really want them. Okay?
And I believe also, if your building has a policy of allowing purchasers or their attorneys to review the board minutes, you'd be very hard-pressed making an argument that outsiders can have our information, but insiders can't. So if that's your policy, you'd be pressed to say no.
Also, you're reviewing the minutes before you do the purchase, so obviously it's a prospective buyer reviewing it, right?
Exactly. Outsider versus insider. I don't know how you can justify not letting an insider have what an outsider has.
And if you put a prospective buyer up, obviously they would generally share the minutes, from my experience.
Exactly. And if not, the building's gonna have a problem selling units.
That's board minutes, or is it annual minutes? Which one are you?
Board minutes, annual minutes, a shareholder in a BCL corporation is entitled to review annual meeting minutes, the shareholder list, and they're entitled to an annual financial statement. That's typically in the bylaws. Again, all this stuff speaks to generalities. Your governing documents may have some quirky language that makes it different, so we're speaking to what we normally see. So you always want to check, but those are the three things that you are entitled to as a matter of right as a shareholder.
So I had a follow-up question. The disclosures you talked about earlier.
Hold on.
You mentioned that you're disclosing to other board members, but is that mandatory to disclose to the shareholders?
Yes.
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 I understood that correctly.
Yes.
Yes, absolutely.
And that's you.
Yes.
What's the question?
The question was, who do you have to disclose the conflicts to? And pursuant to the new BCL 727, which again applies to co-ops, it's also under not-for-profit corporations law, and then based on the April 18th amendment to the BCL to make condominiums fall under real property law, it is a annual disclosure to your owners of the year, whatever contracts you entered into with related parties, that to directors. I suggested an expansion of that to include if you have a board member that's a broker, and also suggested that in some instances management companies that offer services through related management company subsidiaries, you may want to disclose that as well.
In the back.
So if you were voted in to be a board member because transparency in the building was very important, and you're on the board, and some of the discussions have to do with a new lobby and the new floor and the new decorating, how much you as a board member who were the friendliest neighbor to everyone and they voted you in because you were all happy to begin to have transparency, and we were all going to know exactly what is going on. All of a sudden, you're on the board. How much can you say?
That's one of those things that you don't know you're in trouble until you're in trouble. I look at it as, yes, you are represented. You represent some constituents who elected you, just like our government officials, and you have a right to talk to them about what's going on. The tripwire, the difficult part is if you say something that ultimately puts the corporation at risk, that's when you have breached your fiduciary duty and you have exposed yourself to liability.
So by way of example, you have bids out for a project. You're doing your exterior work, okay, and there's a disagreement on who to engage, okay, and you're still in the negotiating process, and you put out the information to your shareholders of what the bids are, and now you've compromised the corporation's ability to get the best pricing. You may be held responsible for damages, okay, because you put the corporation in harm's way. Those are the kind of things we can trip up.
Another example is, let's say one of your fellow shareholders is in arrears, and like Jack had mentioned, they're going through some personal drama. You know, that's something that you've learned as a board member that's private. If you now discuss that with the general population and it causes harm to the person who you just discussed it with, you've just exposed yourself and potentially the corporation to some liability because you really spoke out of school.
Yes. The question was, how much detail do you put in minutes with regard to the particulars? For instance, do you reference a particular apartment or unit or a name? And the answer is, it depends. I know I'm hiding as a lawyer, okay? But for instance, often the minutes will say that with regard to discussion of alterations, the board discussed alterations relating to apartments A, B, C, D, E, F, and G, and what the status is. Perfectly fine with that. If there's a problem with a particular apartment regarding a nuisance, okay, sometimes the board will say the board discussed issues relating to this apartment. Now, if you get into too much detail, because you could be wrong, and now you're publishing something that's a misstatement, you run the risk, okay, of a libel slander. So you got to be careful. And I know it's an art, all right? It's not an actual black and white science. So I can't give you an exact answer. And what I would suggest to you is, and I know it's an expense, and I'm not trying to promote us, okay? Meaning us as lawyers, not us as particular lawyers. A lot of our clients ask that we read through and comment on minutes before they're published, and that's why they do it. All right, you are all volunteers. We get paid to do what we do. And no one will thank you for the great job you did typically, but they will come after you for criticism. All right, I get it. I served on a board. I was a condominium board president for a little while. So I understand both sides. And generally speaking, just be careful and rely. It's okay to rely on your professionals. If you feel like you can't rely on your professionals, find professionals that you feel like you can rely upon. Yes, ma'am.
Can a board member be excluded from meetings?
No.
No.
Chances are not. Let me explain why.
No, but I have to finish my
Okay,
question.
I'm sorry.
Okay. Must a board member sign a confidentiality agreement before he can participate in the meeting?
Well, only if it's in your bylaws.
No, it's not in the bylaws,
Then-
but they're saying that the board member cannot attend the meeting.
Yeah.
That-
So
that-
big picture.
Must sign
Yeah.
a confidential.
Big picture. Board members are fiduciaries. The only way you can meet your fiduciary obligation is if you have full information. So this concept of that we can't give you everything, or you're not an officer, you don't get it, is nonsense. All board members must have all information, okay, in order
And
to
be
do their
permitted to
job.
attend the meetings.
They can't say, you have to leave the room.
Unless the bylaws have some type of
I
a
don't- I don't know.
qualification
I don't-
that's been duly adopted, that would not
I would
be
even
appropriate.
question whether that be enforceable. You can't do your fiduciary duty if you don't have information.
Couple
wrap it
more.
up? We got two more, and we're going to call it.
And we'll stick around informally to
Yep.
address any questions.
Yep.
In terms of communicating minutes out and sharing them with prospective buyers, I mean, what's the regular way to do it? I mean,
They typically make an appointment. Usually, management company maintains the minutes. The prospective purchaser or their attorney makes an appointment with the management company at a convenient time. They go and sit. Typically, they're not allowed to make copies. They can take notes. With phones now, you can obviously take pictures, and that's how it's typically done.
okay, I have some shareholders requesting to have the minutes emailed to them, and that's...
Not necessarily a requirement.
That's up to you. Up to the board. Yes, ma'am.
Conversely, can a board ban a shareholder or homeowner from attending the annual meeting?
Can they ban a shareholder from attendance at an annual meeting?
Right.
By way of example, if you're banned from voting, if you're not in good standing because you've not paid your carrying charges or maintenance, okay, if your corporate documents provide for that, okay, that's possible. That's possible, but it would have to be provided for in your corporate documents in a way that would be permissible. You couldn't say that if you wear a blue suit, you're not allowed. I think it would depend.
I've had a situation where a board member was attacked by a shareholder and had a restraining order, which prohibited them from attending. But absent something like Jack just mentioned, I don't think you could.
Last question, yes, ma'am.
Very quick. If a board member has been accused of a crime, which is a child abuse, can he be barred from the board meetings?
No.
No.
No, no. You'd have to look to your corporate documents as to what would be the process for removal, and you'd have to follow that. And look, let's be very candid. Being accused of something is not being convicted of something, okay? And so we have to be very, very careful. And again, that's a situation where you look to your corporate counsel, you ask for advice, and then you follow it. You don't run off on your own on that one. That's a very dangerous situation because if you bar that person from doing their job, they may have multiple types of claims against you. And if a decision is made that goes bad and that person was not permitted to participate in the process, the rest of the board runs a risk. So I would not recommend that. Look, we want to thank all of you. We're going to stay around. Thank you all for being here. It's our pleasure.